Alright, welcome to the second video on excuse defenses. So again, we're working in this framework where the defendant pleads guilty, then admits to engaging in the conduct, but claims the conduct is excused. So the first video this week focused exclusively on insanity. This one we'll talk about the rest of the criminal excuse defenses. The first one being a failure of proof defense. Here, the defendant, this is a failure of proof defense. The first one being diminished capacity, which is a failure of proof defense. So the defendant argues that they lack the mens rea of the crime that they were charged. And so they are essentially saying that they're that they're probably responsible for a different crime, but not the one charged here because they lack the mens rea. There is a defense called diminished responsibility, too, that is similar in vein, but here the defendant admits what they are wrong, but says, given these other circumstances, I may be less responsible for them. Most states don't recognize either one of these criminal defenses any longer. California abolished it in 2003, and a lot of other states have kind of followed suit. This is just not really in tune with kind of the idea that ignorance is no excuse for the law, with limiting when mistakes can be made, things like that. Our next excuse defense is the excuse of age. Under the common law, there was presumption. If a child was under the age of 7, they had no criminal capacity. In the common law, if they were between 7 to 14, we presumed that they did not have capacity, but that could be overcome with evidence demonstrating this specific child does. And then over 14, children were deemed to have the same capacity as an adult. Today, statutes have really changed a lot. A lot of statutes identify a specific age at which capacity starts. In these states, the average age is 14, but there are some states that have an age of 10 for the beginning of criminal capacity, and other states have it as high as 18. In most of these states, in every state, juvenile courts have exclusive jurisdiction up to that certain age, unless a specific, more serious offense like murder or primarily, but other ones, aggravated assaults and things in some states are included. So juvenile courts have exclusive jurisdiction for juvenile crimes unless it's a really serious offense. Juvenile court jurisdiction is not exclusive in the sense that juveniles can be waived into adult court. This means that the juvenile court gives up its jurisdiction and is passing it on to the criminal court. In some states, prosecutors initiate that. Some states legislate it. So, like, for instance, children under 14 will be in juvenile court unless they commit homicide, which will automatically be in criminal court. It would be a legislative one. But judicial waiver is by far the most common. Here, the juvenile court judge would look at, most frequently, the most common way is the juvenile court judge would look at it and then decide to send the case up for some reason. Your book has a case called State v. KRL. An 8-year-old boy was convicted of residential burglary. He went into a neighbor's house when he was 8 years and 2 months. After the neighbor had yelled at him, and he pulled the goldfish from the fishbowl and chopped it up with a steak knife. Then he smeared it on the countertop. And then he went into her bathroom and clamped a towel around the curling iron. So he was charged with burglary. There was evidence that the mother did not know what happened when she did, she really well, she explicitly testified that after she found out what he did, she told him he didn't seem like he understood what was happening. She talked to him about it for a long time and then admitted that she beat him with a belt black and blue, and that her son told her the devil was making him do bad things. So based on this kind of testimony, it's not readily apparent that this child had criminal capacity. It sounds like he understood that what he did was wrong afterwards because he got into serious trouble with his mom and with the police, but not that at the time he actually understood that this was wrong. So the case was sent back. Okay. So common law, we have those three clear distinctions. Under 7, no capacity. 7 to 14, we presume not. We can rebut, and 14 and over, same as an adult. Currently, we have a statute set a specific age, and juvenile courts can waive into criminal court. So, any questions, definitely reach out. Our next defense is the defense of duress. So duress is an excuse where the defendant says, my actions should be excused because I was forced to engage in this behavior. There is some tension here because societally speaking, it's not, we don't always want to excuse someone who is forced into criminal behavior. We might have some sympathy, but in general, we want people to not commit crimes and not to be forced into committing crimes. The elements of duress, we need to have a nature of a threat. Many states define this threat as a death, or in some states it would also include a serious bodily injury. The threats need to be instant or imminent, that it needs to be right now. In most states, duress is not a defense to murder. It's kind of essentially saying that you don't have the right to decide who should live and die. And you do need to have a reasonable belief that the threat will be carried out. So again, let me know if you have any questions about duress. The next offense is intoxication. There's two types, voluntary and involuntary. For voluntary intoxication, we don't we want to hold you accountable for what you did. You did decide to drink, and you're responsible kind of for your actions after that. And here's an example. From Arizona, noting that, voluntary consumption of alcohol is not a defense for any criminal action, down here at the bottom, and it does not negate any state of mind. Intoxication is a criminal defense when it is involuntary. So this is a situation where you were either forced to consume the intoxicant or you did not know that the intoxicant was an intoxicant. We don't blame people who were involuntarily intoxicated. If you were forced or tricked to consume the intoxicant, we don't blame you. And we want to note that this does not just apply to alcohol. A really classic example was a man thought he was taking a breath mint. That's his friend said, here's a breath mint, try it. And it was actually cocaine tablets. He had no idea that it was cocaine. He thought it was a mint. And while under the influence of cocaine, he killed somebody. So this is the extreme this is the exact type of extreme circumstance where this defense is applicable. Okay, next up is entrapment. Entrapment is where the person is not predisposed to committing a crime, but a government agent got this person to commit a crime that they were not otherwise going to commit. There are two different entrapment tests. One is subjective. So was it the intent, where did the intent to commit the crime originate? If the intent originated with the defendant, then the government did not entrap them. Okay, so if the intent originated with the defendant, it's not entrapment. The government can rebut this argument by displaying prior convictions, willingness to commit a similar crime, displaying expertise in carrying out the criminal behavior, and the readiness to commit the crime. The other type of entrapment test is the objective entrapment test. And here, if the intent originates with the government and their actions would tempt an ordinary law-abiding citizen to engage in the conduct, then that is entrapment. I wanted to quickly switch over here and show you Indiana's entrapment statute. So here we're in Indiana Code 35-4139. And so it's a defense that the prohibited conduct of the person was the product of the law enforcement officer or his agent using persuasion or other means likely to cause the person to engage in the conduct, and the person was not predisposed to commit the offense. Conduct merely affording a person an opportunity to commit the offense does not constitute entrapment. So this is Indiana's specific statute, and it would be a subjective one. Okay, so if the intent originates with the defendant, it is not entrapment. Oops. I think entrapment is, next to insanity, the more confusing excuse. So if you have any questions, definitely email and let me know, or we can talk over WebEx to discuss it. The last part of your book notes that syndromes can be defenses. Particularly, there are states where PMS syndrome or post-traumatic stress syndrome is a criminal offense. I'm not going to spend a significant amount of time talking about that. Your book does a really good job. So just know that there are times where these are excuses defendants can rely on. Otherwise, I hope you have a great week, and please let me know if you have any questions. I look forward to working.